If you have a green card case or a work permit application sitting with USCIS right now, I need you to stop assuming they'll give you a second chance. For years, that assumption was safe. As of this week, it isn't anymore. And if you don't understand exactly what changed, you could lose your filing fee, lose months of your life, and never even know why. Stay with me for the next few minutes, because by the end of this video, you'll know exactly what USCIS changed, who it hits first, what mistakes are now dangerous that used to be harmless, and the specific steps you can take today to protect a case that's already in the system. This isn't scare content. This is the difference between a case that survives and one that quietly dies in a filing room. What actually happened? On August 5, 2026, USCIS published a new policy alert and folded it directly into its policy manual. In plain English, USCIS officers no longer have to warn you before they deny your case. Here's the mechanism you need to understand. In the past, if you filed something and left out a document or didn't quite prove what you needed to prove, an officer was generally expected to reach back out. That reach out came in one of two forms: a request for evidence, which people call an RFE, or a notice of intent to deny, called a NOID. Either one gave you a chance to fill the gap before the door closed. That expectation is gone. Under the new guidance, if your initial filing is missing required evidence, or the evidence you sent doesn't actually establish that you qualify, an officer can deny the case immediately. No RFE, no NOID, no warning shot. And here's the part that catches people off guard. This doesn't only apply to new filings, it applies to cases that were already pending before this change happened. I want to be precise here, because a lot of channels are about to get this wrong for views. This is not a new law. Congress didn't pass anything. This is not a court ruling. This is internal USCIS policy guidance, powerful, immediate, and very real in its effects, but a different category of rule than legislation. That distinction matters if you're trying to understand what can and can't be challenged later. Let's put the two approaches side by side, because the shift is more specific than USCIS got stricter. The underlying law never changed. It has always required you to prove your eligibility and to include the correct initial evidence, meaning the specific documents your form and category require at the moment of filing. That was true last year, it's true today. The regulations have always technically allowed a denial when evidence is missing. What changed is the practice. Under the old approach, when an officer noticed something missing that could plausibly be fixed with more paperwork, the expected move was to ask for it. A denial with zero warning was reserved mostly for cases with no legal path forward at all, situations where more documents genuinely wouldn't have helped. Under the new approach, that safety net shrinks dramatically. If the required initial evidence isn't there, or what you sent doesn't prove eligibility, an officer is now positioned to deny first and skip the conversation. Officers can still choose to send an RFE or NOID. That tool hasn't been deleted. But you can no longer file assuming you'll get that courtesy. The mindset you need going forward: treat your first submission as your only submission. A story that shows exactly how this plays out. Picture someone named Sarah. She has a Form I-485 green card application already pending. While she waits on that, she separately files a Form Y-765 work permit request based on the pending green card case. USCIS instructions for that filing tell her to include proof the I-485 is actually pending. Something as simple as a copy of her receipt notice. She forgets it. One document. Under the old system, she'd likely get an RFE asking her to send it in. Under the current guidance, an officer can deny the work permit application on the spot without asking. Now, here's the detail almost nobody explains clearly. Her work permit and her green card case are two separate benefit requests in the eyes of USCIS. A denial of the I-765 does not automatically kill the I-485. But think about what it does cost her. No ability to legally work while she waits, a disrupted income plan, another filing fee, and months added back onto a timeline she thought was almost finished. One missing photocopy. That's the scale we're talking about. Rejection and denial are not the same word, and the difference matters. Quick but important distinction. A rejection usually happens before USCIS even accepts your case for review. Wrong fee, missing signature, filed at the wrong location, that kind of basic intake error. A rejected case typically loses its filing date, which matters enormously for priority dates and deadlines. A denial is different. That happens after USCIS accepts your filing and actually reviews it, then decides you haven't proven what you needed to prove. This new policy is about that second stage, the actual adjudication, but don't let that make you sloppy about the first stage. Getting your intake basics wrong can knock you out before this policy even becomes relevant. Who gets hit first? This isn't limited to one visa category. It touches people adjusting status, work permit applicants, family-based petitioners, employment-based petitioners, and people requesting an extension or change of status. If you're filing anything with USCIS, this applies to you in some form. But, and this is critical, the risk level is not identical across categories. Marriage-based cases, employment-based cases, asylum-related filings, and humanitarian categories each run on different evidence requirements. Two people can file the exact same form number and still need completely different supporting documents because their underlying eligibility category is different. There is no universal checklist that protects everyone equally. One more clarification worth making before people panic in the comments. This is a USCIS policy. It governs benefit requests decided inside the United States. It does not directly control visa interviews at embassies or consulates abroad. That's the State Department's territory. And if you already have an approved green card or an issued work permit in hand, this alert does not retroactively strip that away. Different legal processes govern any future loss of status. Don't let anyone tell you otherwise. Risk. Number 1. Evidence that looks complete, but isn't. This is where most denials are going to happen, and it's sneakier than people think. A document can physically be in your packet and still fail to prove what's required. A marriage certificate proves a legal registration. It doesn't automatically prove the relationship is genuine. A job offer letter proves an offer exists. It doesn't automatically prove the employer or the role actually qualifies under the category you're filing. Imagine a company filing a petition for a worker. They include the forms, they include a support letter. Everything looks thick and thorough, but they leave out one specific company document the category requires. Under this guidance, an officer can treat that missing item as required initial evidence and deny the whole thing without ever asking for it. The lesson here: stop counting pages. Start connecting requirements to proof. For every single thing your category requires you to establish, ask yourself, which exact document proves this, and is it current, clear, and consistent with everything else in the file? Risk number 2. If you do get a notice, the clock is not your friend. If USCIS does send you an RFE, the outer limit is still 12 weeks. For a NOID, it's still 30 days. Those legal ceilings haven't moved. But here's what you need to internalize. 12 weeks is a maximum, not a guarantee. An officer can give you far less time depending on what's being asked and the specifics of your case. Whatever date is printed on your actual notice is the one that governs you, not whatever you've heard online. Some documents take real time to gather: payroll history, foreign civil records, school transcripts. If you sit on a notice for 3 weeks before you even start collecting evidence, you may run out of runway. And here's a mistake that trips people up constantly. Say someone receives a notice asking for 4 separate items. They gather one quickly, send it in, and plan to send the rest later, thinking they're making progress. That can backfire badly. USCIS guidance treats a partial response as essentially a signal that you're ready for a decision based on what's currently in the file, meaning they may just rule on the incomplete record instead of waiting for the rest. Never send a notice response in pieces. Gather everything, answer every single point, and submit it as one complete package before the deadline. Before we move to the next risk, understand why this one matters more than people think. This exact mistake, a technically present but legally weak document, is going to be the single biggest cause of denials under this new policy. Not fraud, not bad intentions, just documents that look right but don't actually prove the point they're supposed to prove. Risk number 3, when you don't have the normal document. This one matters enormously for people relying on foreign records. Say the standard document, a birth certificate, a marriage certificate, simply doesn't exist for your situation, maybe because your home country didn't issue them the year you were born. There's a hierarchy here. Primary evidence is the standard official record. If that's genuinely unavailable, secondary evidence can sometimes work. School records, religious records, medical records, but only after you've shown the primary record can't be obtained. If even secondary evidence doesn't exist, a sworn affidavit from someone with direct personal knowledge may be usable, depending on the specific benefit involved. The mistake to avoid is leaving that section blank and hoping nobody notices. Explain the gap. Prove the primary record is unavailable, provide the best secondary evidence you can, and add an affidavit if it's permitted for your category. Make the officer's job easy. Don't make them guess. And don't forget translations. Any foreign language document needs a complete English translation with a proper translator certification attached. A summary is not a translation. Under a stricter evidence standard, a shortcut like that is now a real liability instead of a minor inconvenience. Now, here's the question. Everybody watching this actually wants answered, so let's not dance around it. What a denial actually costs you, long term. Let's say the worst happens and you get denied. Does that end everything? Not necessarily. Remember Sarah's story, where her work permit denial didn't automatically kill her green card case. But other denials can hit much harder, especially when what's denied is directly tied to your lawful status or your ability to remain in the country. Depending on your situation, you may have options: filing again, a motion to reopen based on new evidence, a motion to reconsider if you believe USCIS misapplied the law to your existing record, or, in some cases, an appeal. But these paths aren't available for every form. Deadlines can be brutally short, and refiling usually means a new fee and a new filing date. You generally don't keep your old place in line. There is no single universal backup plan that works for everyone. Anything you consider has to match your actual facts and your actual case. Read your denial notice line by line. It will tell you what's actually available to you. Let's kill 3 rumors before they spread. Rumor 1. Every pending case is about to be denied. False. Every case still stands or falls on its own law, facts, and evidence. Officers can still issue RFEs and NOIDs when they choose to. Rumor 2. USCIS will never send another RFE again. Also false. The discretion to ask for more evidence still exists. What changed is that you can no longer count on it as a safety net. Rumor 3. One missing document leads straight to deportation. False, and this is the one that causes the most needless panic. A denial can affect your status and your options depending on your facts, but this policy does not create automatic removal proceedings just because a document was missing. Okay enough about what can go wrong. Here's exactly what to do about it, step by step, starting today. What you should actually do. Right now, if you're preparing a new filing, start at the current official form instructions. Not a template you found from 2 years ago, not a comment section checklist. Confirm the correct form edition, the filing fee, the mailing address, signature requirements, and category code if one applies to you. Build yourself a simple evidence chart. 1 column for each requirement your category demands. 1 column for the exact document that proves it. Check that names, dates, and addresses are consistent across every page. Get full certified translations for anything not in English. Keep a complete copy of everything you send, along with proof of mailing or delivery. If you already have a case pending, go back and compare what you actually submitted against the current instructions. Look for anything expired, unclear, missing, or inconsistent. But don't panic mail extra documents to USCIS with no plan. Unsolicited paperwork can get lost or raise new questions instead of solving old ones. This kind of review is about getting ready for a possible notice, an interview, or a real conversation with a qualified professional if you find something seriously wrong. If a notice does land in your inbox or mailbox, read every page the day it arrives. Write the deadline somewhere you'll actually see it. List every single item being requested. Gather your strongest proof for each one. Submit one complete, organized response, never in pieces, and use a delivery method that gives you confirmation it arrived. And this should go without saying, but never submit false information, fabricated employment, or altered documents to try to patch a gap. That risk is categorically worse than a denial. If your situation involves anything more serious, a fraud allegation, a criminal history question, prior violations, removal proceedings, or a deadline you don't fully understand, that's the moment to stop watching videos and go talk to a qualified immigration attorney or accredited representative. This change makes complete, well-documented filings more important than they've ever been, but it does not mean your case is doomed. Strong cases, filed correctly, are still approved every single day. Some applicants will still get an RFE. A pending case is not a denied case, and a notice is not a final answer. The real takeaway is simple. Stop filing and hoping someone will tell you what's missing. Prove your eligibility completely the first time, because right now, the first time might be your only time. One last thing before you go, because it matters. Everything in this video reflects what was publicly known about this policy as of early August 2026, and it's meant purely for general education. It is not personal legal advice, and immigration rules can shift again without much notice. Every single case is different, built on its own facts, its own history, and its own risk. If you're dealing with an actual deadline, a denial letter, a criminal record, prior violations, or anything tied to removal proceedings, please talk to a licensed immigration attorney or an accredited representative before you act on anything you heard here. If this broke the policy down in a way that actually made sense, do me a favor and hit subscribe. More of this is coming.